Hello, my name is Joe Facenda. I am a realtor with Remax Gateway here in Northern Virginia, just outside of Washington, D.C. And I've been a realtor here for over 30 years. I've also made working with inherited property a specialty of mine over the last several years, and I've even written a book on inherited property called When Parents Are Gone, What's Next with the House, and the book is available on Amazon. In this video, we'll discuss a few things that you should do early in the process, regardless of whether you're keeping the property, renting the property, or selling the property. Some things you should do to avoid potential legal issues down the road. And we'll also discuss something you might want to do if you plan to keep the property or rent the property to help get out in front of any potential tax consequences down the road. Okay, let me tell you the most important piece of advice that I can give you in this whole video series, and that is have a title search run on the property early in the process. And if you're going to sell the property, have a title search run before you go on the market and before you get under contract with a buyer. What is a title search? Well, title search is usually done by a real estate settlement company, a real estate attorney. Somebody goes to the courthouse to research the title history of the property. They look at the transferring of the property for the last several decades. They look to see if there are any mortgages or liens against the property. They look to see if there are any judgments against the owner of the property, which can potentially attach to the property, and if there are any other legal issues involved with the property. Now, if you own property right now, you pretty much know your financial situation. I mean, you know how many mortgages there are on the property. You know if you've had any judgments against you recorded at the courthouse. You know where documentation is to clear up any issues if the courthouse has something recorded in error. But when a person is passed, the documentation is harder to find. The documentation may be missing. It may take a longer period of time to solve issues, and there may be surprises at the courthouse. And it's very important to find these surprises before you put a property on the market. There's nothing worse than being under contract and then finding that you can't settle because of some legal issue on the seller side of the table. So what are some of the common problems that you might find at the courthouse? The most common is what's called an unreleased trust. An unreleased trust. Maybe your dad, who just passed, paid off the mortgage 10 years ago, and you don't think there's any mortgage on the property, and there really isn't. But when he paid off that mortgage, he got a letter from the bank saying, "Congratulations, your mortgage is paid off." But perhaps no one went to the courthouse to release the lien that was against the property. Most likely, the mortgage company or the bank should have sent some notice to the courthouse stating that the loan had been paid off. It happens more frequently than you would think that this does not get recorded. So to the world, there's still a lien on the property, and you have to prove that the mortgage has been paid. Again, if it's your own house, you have the documentation, the letter of satisfaction, whatever your bank sent you. You can give that to the title company. They can call the bank and verify. It's a lot easier. But if you don't have that documentation, it's going to be a lot harder to get that lien released. Sometimes I've experienced that heirs think that there's just one mortgage against the property, and they find out that there are other mortgages against the property. Maybe they didn't know that dad took out a HELOC. Maybe because they had not seen any bills, they couldn't find any bills for that second trust. So they weren't aware of its existence. First trust and the second trust need to be paid off when you sell the house. And if those two totals exceed the value of the house, we're in a different arena. And regardless, if there's a second trust with the balance, it changes the numbers of who's inheriting and the amount that people are inheriting. And it's best to know that up front and have surprises at the settlement table. So you want to know if there are any mortgages at the courthouse or the number of mortgages match up to what you expect. 0, 1, 2, whatever. The second most common thing that we find is that there are judgments against the deceased that nobody knew about. It's very possible that there's some kind of, that maybe there was some kind of financial situation that developed in the life of the deceased and they didn't share it with everybody, and maybe there's a judgment out there they thought was going to be eventually taken care of, but they passed and it's still lingering out there. All judgments against any owners of a property that are recorded at the courthouse, I'm not talking about late credit card bills and things that have not gone to court, but anything that went to a court and there was a judgment against a property owner and it's recorded at the courthouse, it needs to be paid off as part of a sale. If you're going to sell immediately, of course, you want to get out in front of this and know what it is. If you're going to keep the property, some point down the road, that property will be sold. 5 years, 10 years, 15 years, 20 years, I don't know. But that judgment, if it's there, continues to accrue interest and grow. So it's a good idea to know now that there is maybe a potential judgment against the deceased. And what people also don't realize is that judgments against the heirs matter just as much, because the property has been transferred to the heirs, and any judgments against the heirs could attach to the property and they need to be cleared. Had a case a few years ago with 4 sisters, and one sister had a very small judgment, a couple of $100, and she had years before gone through a divorce, and she was unaware that this judgment was out there against her because her ex-husband was supposed to have paid that off, and he didn't. And she said, I am not paying off this judgment because it's not my responsibility, it's his responsibility. Well, eventually common sense prevailed, and the other sisters got her to agree that the judgment would come out of her proceeds, and they were each receiving tens of thousands of dollars. And on principle, she didn't want to pay a couple of $100 judgment. But it's important to know if these judgments are there. So unreleased trusts, judgments are the most common, but there are other things that crop up. There was a situation I had a few years back where there were 3 sisters. Mom and dad divorced after the last sister was born decades ago. And they were inheriting the property from dad, who after the divorce had a girlfriend, and from that relationship there was a child. The 3 sisters were not 100% sure that this child existed or that it was their dad's child, so they never really talked to me about it. We did the title search, and this newly found sibling, had filed a lien or some type of paperwork at the courthouse saying, hey, I want my share of the estate, and I need to sign all paperwork and make sure I get my share of the sale of the house. Little bit of a legal something going on between the 3 sisters and this new sibling, but we didn't put the house on the market until this was resolved because all heirs need to sign all paperwork. So eventually they all agreed that this sister would share in some percentage of the proceeds or whatever, or the new sibling would share in some percentage of the proceeds with the 3 sisters. So you need to get into the courthouse records regarding the property to make sure there are no surprises. Nothing worse than getting under contract with a buyer and finding out that you can't settle because of some issue on this legal issue on the seller side of the table. Okay, Now, let's briefly talk about taxes. Again, I'm not a CPA, I'm not an attorney, but I can give you a quick overview of the tax treatment of inherited property. You have inherited the property at what's called a step-up basis. Step-up basis means that you have inherited the property at the value at the time of the person's death. So if you have inherited a property worth $600,000, it's irrelevant that your parents purchased it for $20,000 decades ago. That $580,000 difference is not subject to any kind of a tax. You inherit the property at $600,000. If you hold on to the property, keep it in the family, rent it out, sell it 5 years, 10 years, 20 years from now, doesn't really matter. That $600,000 is your basis, and if you sell it for $900,000, the $300,000 difference could be subject to capital gains. You need to talk to an accountant or whatever. But that $300,000 would, under today's laws, could be subject to capital gains, and who knows what laws will be when you go to sell the property. So what I would like to suggest is that if you're going to keep the property either in the family or keep it as a rental, is to get what's called a time of death appraisal. And that would be having an appraiser come out and evaluate the property now to have documentation as to its value today, so that when you go down the road, years down the road, decades down the road, and sell the property, you'll have some kind of documentation to use for the basis of the sale. Now, if you're selling the property right away, different accountants will have different opinions on whether you need a time of death appraisal. Some will say that if you're selling the property in relatively the same season as the death of the prior owner, that the market value you sell the property for is the stepped up basis. So there's no tax consequences because you sold it at market value, inherited at market value. Other more conservative accountants might say it's best to have the time of death appraisal so that we can know that in March it was valued at this, and even though you sold it in June, we should have that value of time of death. So talk to your accountant to decide what you want to do. But if you're selling a property, realize that any commissions that you pay, any closing costs that you pay, any repairs that you do to prepare the property for sale, all come out of the sales price before you calculate capital gains. Let's say your father passed, and the time of death appraisal said that the property was worth, again, $600,000. And a few months later, you sell the property at $630,000. That $30,000 is most likely not going to be taxed, because you're going to be deducting commissions and things you did to prepare the property and repairs you made to the property and other things like that. But again, check with an accountant and do what they suggest. If they might say to do a time of death appraisal when you're selling the property quickly, they might say don't worry about it. Take their advice, not mine. I just want to share the concept and give you a question to ask your CPA. So I hope this has been helpful. This video has been a little bit longer because some of the concepts are a little more complicated. But I think it's very important, and this video contained, again, the most important advice I can give you when inheriting a property. Have a title search done on the property as soon as is practical. Okay, next we'll discuss what to do with the property once you've cleared the legal hurdles and if there's any surprises at the courthouse. Should you keep the property? What are the pros and cons of keeping the property? What are the pros and cons of renting the property, and what are the pros and cons of selling the property. So if you're sure of which one you want to do, go right to that video. Otherwise, listen to all three. Wherever you go next, I'll see you there, and we'll continue the conversation. Thank you so much for watching this video.